Today, I want to talk about the ThedaCare versus Ascension Northeast Wisconsin case. Judge grants ThedaCare temporary injunction in stroke team case. On Friday, an Outagamie County judge ruled in favor of ThedaCare and issued this order. Make available to ThedaCare one invasive radiology technician and one registered nurse of the individuals resigning their employment with ThedaCare to join Ascension with their support to include on-call responsibilities, or cease the hiring of the individuals referenced until ThedaCare has hired adequate staff to replace the departing invasive radiology care team members. This case has just blown up because of the perceived injustice of it. Thursday morning, ThedaCare filed for a temporary injunction against Ascension, saying that it could cause the community harm by recruiting a majority of ThedaCare's comprehensive stroke care team. The various reports are that there was a team of 11 people and 7 members of the team left ThedaCare to work for Ascension for a better pay and benefits package. ThedaCare operates the only Level 2 trauma and comprehensive stroke care unit in Fox Valley. It says losing these workers could impact its ability to have people on call 24/7, which is necessary for its accreditation. And depending on where you fall on the whole worker shortage problem, you could have really one of two perfectly valid positions. One position would be, yeah, if I'm a stroke victim and I need to go to ThedaCare, I'm going to really want them to have proper staffing so that I can have my stroke diagnosed and treated as quickly as possible. On the other hand, Wisconsin is what we call an at-will employment state, which means that the hospital can fire its workers at any time for any reason or no reason, and the workers can leave at any time for any reason or no reason. If the hospital needs these workers for its accreditation, all it has to do is pay a wage that is attractive to those workers. If the hospital doesn't offer a wage that attracts the 11 team members it needs for accreditation, that's on the hospital. But what has happened now is ThedaCare has made a motion for a temporary restraining order. On the 20th, which was Thursday, they filed a complaint. We don't have the text of the complaint. And then they made a motion for a temporary restraining order and temporary injunction. And then on Friday morning, the temporary restraining order was entered by the judge, Mark J. McGinnis. Now, I've seen reports that this judge has a history of questionable decision-making as well, but I don't have any information about that. So just keep that in the back of your mind that maybe this is a crazy decision by a crazy judge, but I'm going to approach it from the legal perspective, whether this has an explanation that might not be so sinister. It seems like, just based on the docket, that ThedaCare was able to get their temporary restraining order ex parte, or without the other party. If there was another party there, it doesn't seem like there was a chance to respond to the temporary restraining order motion before the restraining order was entered. However, it does look like they scheduled a hearing, and the hearing on January 21st, which was Friday, the temporary restraining order seems to be in place, and then there will be another hearing on the 24th at 10 a.m., which is tomorrow morning as of the recording of this on Sunday the 23rd. And I thought for a second we could go over what I think is really going on here. There are legal reasons why I think this might not be as sinister as it's being made out to be. It is normal for a judge, for a court, to want to maintain the status quo, put things back to the way that they were when things were okay, before the dispute happened, until the judge can have a chance to resolve the dispute in some kind of proper adjudication. So Ascension files the thing on Thursday, they have a hearing on Friday, the judge says, okay, for now, the employees have to work at ThedaCare, at least 2 of them have to work, or at least Ascension can't hire them. And then very quickly thereafter, it has to be quite prompt for a temporary restraining order. Very quickly thereafter, we will have a larger hearing with more evidence, and we'll see if the judge sustains their decision. Why the judge would enter that temporary restraining order certainly could be crazy and sinister, because it's an at-will employment state. There's no evidence that these are contract employees, that these employees work under some kind of contract, that they are required to give 2 weeks notice, or they're required to work for a year or whatever before they're allowed to leave, or that they are essential employees in some way. It sounds to me like these are just plain old at-will employees, which means they can leave whenever they want. So how could a judge tell them that they have to work for ThedaCare when they already quit? Well, based on the text of this, and based on the lack of these employees being defendants in this case, I'm going to guess that only Ascension could be ordered to do something, and that's why the judge ordered Ascension to make one technician and one nurse available to ThedaCare. Who's paying their wages? I don't know. Are those wages going to be the new wages? Will ThedaCare have to take the one technician and the one nurse and pay them the new wage that they bargained for with Ascension? I don't know. Those are reasons why you shouldn't order people to work at a job that they quit. That sounds an awful lot like some kind of slavery, which is barred by the 13th Amendment, except for prisoners. And there's no way that the judge can really order employees to work for a different hospital. However, if they take their job with Ascension, and Ascension says, as part of your employment at Ascension, you now have to work for ThedaCare for however long until they get new staff to replace the departing team members, maybe Ascension bills ThedaCare for the new pay rate. That sounds fair to me. Or Ascension can simply cease the hiring of the individuals, which also sounds really unfair. If I just got hired and now you can't hire me anymore, now I'm suffering damage. Now I'm being damaged because I'm not getting paid by ThedaCare anymore. I'm also not getting paid by Ascension. So this is a terrible situation that really shouldn't ever exist. However, there's a little bit of a light at the end of the tunnel for the employees. They have so far raised $44,665 out of a $50,000 goal. And let's see, it's gone up to $45,493 as of my refresh right now. So they're at least going to have some funds to tie them over until this thing gets resolved. And there will be a hearing tomorrow at 10 a.m. unless it's continued. And at that point, I have a feeling that Ascension will have a chance to make all of their arguments. I understand that these employees are going to attend that hearing and object to the judge's temporary restraining order. My guess would be, upon hearing how unjust this is for the employees, that the judge would cancel or terminate the temporary restraining order, or the parties might reach some kind of agreement that Ascension will continue to hire the employees, but 2 of them will work at ThedaCare for now, but at their new rate and benefits package. That sounds like a good alternative. Not that they're slaves, not that the court is ordering them to work, because the court can't order them to work for ThedaCare. What the court is trying to do is maintain the status quo until they can have a bigger hearing. And then if at tomorrow's hearing the judge says, no, you 7 employees have to go back work for ThedaCare until they can hire new people, that's where we can start to say, no, that's improper. That's, I don't know, I'm being a little bit hyperbolic. It's not necessarily slavery, but it does sound like the government ordering you to work, and the government can't order you to work like that, especially when you've taken another job and it's an at-will employment state. I do see a lot of misconceptions about what at-will employment means as well. Someone will post on a forum like the Reddit anti-work forum, and they'll say something like, my employer isn't paying me overtime. What can I do? And somebody like me will say, to contact your local Department of Labor Wage and Hour Division. They have to pay overtime and they can't retaliate. And then someone will say, they're in an at-will employment state. They can just terminate you for asserting your rights. And then someone will say, well, that's retaliation and they can make a claim. But they'll make up some reason why they're terminating you that's not the reason. That's not quite how it's supposed to work. If the employee is willing to vindicate their rights, what's supposed to happen is they make a claim for their rights. If the employer retaliates, then the employee makes a claim for retaliation. And it's pretty simple to prove the retaliation. Maybe we can go over this in detail. Maybe there's some interest in going over some case law about what exactly retaliation is. In my previous video, I did go over some examples of what retaliation looks like, but we didn't go over like entire cases. So that might be something that you're interested in. But the point is just because it's at will doesn't mean you don't have rights. The employer can release the employee or the employee can quit at any time, but that doesn't mean there aren't consequences. If there was a violation of contract, there's a breach of contract. If there was an unpaid overtime claim, then you still have that. If there's retaliation, like you got fired because you made an unpaid overtime claim, that's still a claim, regardless of whether they had the right to fire you at will. You still have all of those rights. The problem I see is that most employees either don't know or don't want to vindicate their rights. Employment law attorneys could be expensive or overworked, and you can't just easily find somebody. Employees or former employees, claimants, might not be willing to go to court by themselves without an attorney. This is the access to justice problem that attorneys like me talk about regularly, but that doesn't mean that that's how the law works. It's just that's how it practically plays out when one party, the victim, is not willing to vindicate their rights. So back to the ThetaCare situation, it's my best professional guess that the judge entered a very temporary restraining order until he could have a more complete hearing on the subject. And that's why there was such a restraining order on Friday and another hearing scheduled for Monday. I'm really looking forward to what happens at the hearing tomorrow, because that will help inform whether the judge was just acting crazy or whether the judge was trying to get the status quo protected while trying to figure out whether there is a basis for keeping these employees employed at ThedaCare. What would be a real injustice would be if the judge was able to force the employees to go back to ThedaCare for the old wage after they just did all the work of getting a better job somewhere else. I thought that in America, we encourage people to find the best job and make the most money and all that, instead of simping for the employers who pay their employees less money than they're worth and pocket the difference. I appreciate how capitalism is supposed to work, but I also believe in work-life balance and paying a living wage and paying a wage to people that is appropriate for their level of experience and such. I had this problem at an old employer of mine, and I made claims because I was not paid appropriately. And I think you guys know the rest of that story. My attorney didn't prosecute the thing properly, and later on was suspended for 5 years for his violations. I actually did find an interesting article here on SHRM analyzing an anti-poaching agreement as a non-compete agreement. A Wisconsin Court of Appeals has confirmed that a former employee's agreement not to solicit other employees may be void and unenforceable if it is too broad. The employer contended its agreement not to solicit, induce, or encourage employees to terminate their employment or accept employment with a competitor, supplier, or customer was not a restriction on competition. The court roundly rejected that claim, noting that the company had spent more than $1 million in legal fees and costs to stop the former employee from systematically poaching its employees. It is not a leap of logic to conclude that a provision aimed at restricting a former employee from systematically poaching the valuable and talented employees of his former employer is a restraint on trade. In other words, you're not supposed to restrain trade by denying employees the right to move on to another employer. And this is very similar to the fact pattern here, where one former ThetaCare employee got the new job, simply told the other ThetaCare employees about the new job, and then those employees left ThetaCare of their own accord, at least according to the reports that I've read. If I've got the facts wrong there, that's fine. We will adjust our understanding based on the new facts. But currently, we don't have access to the court documents, so it's impossible to see what ThedaCare's arguments are. ThedaCare did put out a press release. ThedaCare seeks to protect access to local trauma and stroke care, to protect the community's ongoing local access to level 2 trauma and comprehensive stroke care provided at ThedaCare Regional Medical Center, NENA. ThedaCare filed for a temporary injunction in the Outagamie County Circuit Court against Ascension. ThedaCare's action asks the court to provide time for ThedaCare to replace the majority of its 11-member interventional radiology and cardiovascular team of nurses and technicians who were recruited by and have accepted employment offers at Ascension. The false part of that, again, based on reports only and not from any firsthand knowledge, but I'm told through multiple reports that the nurses and technicians left of their own accord, and they were not recruited by Ascension, but rather simply told that Ascension had given one employee better pay, a better benefits package. So the other 6 employees of ThedaCare then applied and were accepted. Now, it could be something in between. Maybe Ascension told the one employee, oh yeah, we need 5 more, 6 more people, go tell your friends. And maybe that's considered recruiting. But if Ascension simply gave somebody a better benefits package and that employee went back and told the others, and the others applied, were hired, and then quit ThedaCare of their own accord, then that's not Ascension recruiting them, and that fact would be false. So that's something to pay attention to. That's a contested fact right now. We understand and respect that people have choices in the current highly competitive job market. I mean, if ThedaCare had simply paid their employees an appropriate wage and benefits package, then those employees wouldn't have left for another hospital. The decision by Ascension to hire away such a significant portion of ThedaCare's support team all at once, and at the height of a pandemic surge, will disrupt access to critical care for the people in our region. While we have tried to work with Ascension for additional time to execute a plan for staffing coverage that will provide the long-term continuation of services that support trauma, stroke, and other essential areas of care, Ascension was unwilling to collaborate with us. We are essentially asking the court to grant the injunction to maintain the status quo until ThedaCare can hire replacement staff for this vital department in order to protect access to the critical care services supported by the team, which are community assets. I think that's a really long-winded and businessy way of saying that ThedaCare didn't properly plan for losing employees by paying them too little. In order to maintain the level of staff that you need to provide the care you provide, as well as to keep your accreditation, then you need to be ready to hire people when people quit because you're underpaying them. This really blows my mind that they can't look at themselves as having responsibility for maintaining their own staffing levels. There are a lot of people out there that are quick to blame the employees. I enjoy the derogatory phrases like eat less avocado toast and have less Starbucks. Well, ThedaCare needs to eat less avocado toast and have less Starbucks and pay their employees a living wage, an appropriate wage for their experience and the demand that the market will bear right now. It's really interesting to me how when it's the employees who are suffering, that's okay. But when it's the business that's suffering, then when we get court intervention in order to keep staffing at necessary levels so that we don't have to pay them a proper wage. It's not the employees' responsibility to maintain ThedaCare's staffing levels. This is a level of victim blaming that just doesn't fly. And I think that's why you see people outraged right now. I do not know what legal basis ThedaCare could possibly have cited that got the court to issue the injunction in the first place. I could not find an anti-poaching law that Wisconsin has, and nor did I find anything that requires hospitals and nurses and staff to not leave at will. It seems normal to expect that your employees can leave at will, just like ThedaCare had the right to fire them at will. I also saw some reports that the judge's order is not enforceable. And there's a yes and there's a no to that. It's possible that it's not enforceable, but the proper way to fight the order would be to appeal the order. So as an attorney, if it was my case, I would go to court tomorrow. I would win or lose, but if I lost and I didn't like the judge's order or didn't think it was enforceable, then I file an appeal and ask the appeals court to invalidate the underlying order. Plus, I would also ask the lower court to stay their order pending the appeal. This might happen in both directions. If ThedaCare loses tomorrow, ThedaCare might go to the appeals court and ask them to implement the order while the appeal is pending. So this could actually be a couple days to weeks of a fight trying to get justice for these employees. Fortunately, it looks like they have a GoFundMe to help them with their legal fees and with their personal income and expenses. So this is another case of FAFO, F around and find out. ThedaCare effed around with employees' pay, and they found out that the employees were willing to leave. And it just happened to be that 7 left at one time. And you don't see the local McDonald's going to court when employees leave because they've been mistreated or underpaid. But you do see ThedaCare doing that. And I think that's about as terrible as it can get when it comes to labor rights, to get a court order requiring employees to go work for the old employer because they didn't want to pay them proper wage. Let me know what you think in the comments below. Thanks for watching. Special thanks to our top supporters in January: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, NotMike, ShadowTycho, Earthbound Star, TechTechPotato, Eric Tams, PureMagma, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsus.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week and a happy new year. I love you all. Bye.